All right, good afternoon, everybody. Welcome. It's 3 o'clock on my watch, so we'll make a slow start. Thank you. I'd just like to welcome everyone to this afternoon's training webinar. The topic is HR training for sectional title caretakers. We also have trustees in our audience, so welcome. And I've also asked our PM teams, our portfolio managers and portfolio administrators to participate because I think it's such an important topic. This is our second training module in a 9-week series. We'll convene every Tuesday at the same time, 3 o'clock. And the topic next week is on maintenance and the important provisions of the Occupational Health and Safety Act for sectional title schemes. So that's next week's topic. Please do feel free to refer this training webinar series to any of your contacts or colleagues or friends. They're more than welcome to join. If you don't have the registration link to send to them, you're more than welcome to refer them to me or ask me for the registration link, which I can send to you. At the end of today's presentation, you'll see contact details once again, where you'll be able to send any questions that aren't answered today. You'll also be able to ask for the presentation slides, and we'll also be able to send you a YouTube link of the recording from the webinar. So that will all be available to you. Hopefully all of your questions were answered last week if you did attend, and hopefully you did receive the slides as well as the webinar link, those of you that would like to. The pace of last week was fairly fast. There were a lot of new terms and concepts and definitions that some of you might not have been aware of. I'm hoping that we will come across those again over the next 7 weeks, and there certainly will be an opportunity to recap on some of those, to refresh some of the definitions. You're more than welcome to ask any questions about those, and we'll be very happy to answer them either on the webinar today or in the weeks to follow, or by email as you prefer. Just a reminder that at the end, a survey link will pop up, just asking for your feedback on the webinar, what we can improve, other topics you'd like to have covered, any questions that you've got. It'll take a minute or so to answer, so we'd appreciate your feedback, which we will be reviewing afterwards. And we do take that into account with each and every week's webinar. I'd also like just to remind everyone that those of you that attend all 9 of the training modules will be eligible for a Trafalgar branded training certificate to confirm that you've completed the Caretaker sectional title course. So that will be available, and we will send that to you in a nice Trafalgar branded certificate. We do get from Zoom a attendance register of those that attend, so we are able to track everyone that's logged in and participated in the training. With those introductory comments completed, I'd just like to introduce you to our panel today. We've got Belinda Simon, who's our HR manager in Pretoria, waving there. So Belinda will be facilitating the slide discussion today. Belinda, welcome. Thank you very much indeed. And Belinda's put most of the slides together today. Next to Belinda on my screen is Lunita Adrian. Lunita's the HR manager in our Cape Town branch. So welcome, Lunita. And Lunita will be involved in answering any questions that are posed today. And please feel free to write your questions on the Q&A section. You'll see the button below. So please do write any questions you've got at any time. And Samira, who you don't see, but Samira is our national HR manager based in our Durban branch. Samira will facilitate grouping and answering of the questions and moderate the discussion. And if there are not enough questions, I might pose a few myself as well. And then we've got Adele Willefeer also on our panel today. Adele is our Pretoria branch manager and has been integral to arranging the training series. Welcome to all my colleagues, to the panelists, and thank you very much for putting our training session together today. Before we kick off, I'd just like to say that this is an absolutely important topic. They're all important, but I do think this is an especially important topic. Many of yourselves have employees at your buildings that are working with you and alongside you. And it's absolutely essential that the HR function in terms of their employment, their payroll, their contracts, etc., is professionally managed, is set up correctly from the outset. And that ensures that there's a professional, a continuing, and an accurate employment relationship with those individual concerned. And I think the scope of the discussion today will be to go through the relevant topics, the relevant considerations to equip you with the necessary information to fulfill an effective and a responsible and a legally compliant HR function in your buildings where there are employees working for the body corporate or the homeowners association, as it might be. All right, so with that in mind, Belinda, may I hand over to you and we'll make a start with the presentation. Thanks very much indeed.
Thank you, Andrew. I just want to say welcome to everyone today, and well, thank you for joining this training. Without you, the training will not be possible. So like you can see on the first slide, the future depends on what you do today, and it has all to do with the main aim of this training is that you walk out of here with all the knowledge that you need in order for all of us to be compliant according to the Labour Relations and the Basic Conditions of the Employment Act. So we will continue with the training right now. The very first slide that you can see on the webinar is the employee cycle. Now, every one of us is an employee, even if you employ someone or if you work for someone. So employee cycle works as follows, and this counts for every section that employs staff, is that a vacancy will start out in a company. So when a vacancy starts out, it means there's a vacant position that needs to be filled. Then recruitment will take place. Now with recruitment, that happens when we do advertisement, we recruit CVs, we shortlist it for the body corporates or the trustees in order for all of us to have then an interview. Normally there's a first interview where we approximately have about, say, 10 applicants. We then shortlisted to 5, where you have a second interview. And then with the second interview, then you have your final interview, where it's normally a shortlist between 2 or 3 candidates. What Trafalgar also recommend is that all body corporates or trustees must then be compliant with credit and reference checks. Now, credit and reference checks are very important, especially when it comes down to financials. If staff members work on finances or anything with finance, then it will be preferable to know that their credit record are in place. And then also reference checks. Now, reference checks are very important because you need to know what the background of your employee was and what type of employee he was with his past employees or employers. So reference checks are normally important, and what we recommend is at least 2 reference checks that you can do with past employers to get a feel of the employee, and you need to know, because we all know with an interview, an employee is never, ever honest about his past employment. So the best part would be to contact the past employees and to get the correct reference checks. Then after the recruitment, then comes the employment offer. The employment offer is where the body corporate or the trustees makes an offer to the employee. This will now include your letter of appointment, the role profile, which is very important, and that basically tells the employee exactly the duties that he or she will perform within the company or in the body corporate. The documents also includes obviously the salary, and if there's any provident funds or medical aid offered by the company. And then once all the documents has been signed by the employee and the trustees in this case, then the employee can then be loaded onto payroll where the statutory payments and deductions will take place. So we have the vacancy, we have the recruitment, and we have the offer of employment thus far. After the offer of employment, your employee has been welcomed on board, and it's the first day at the body corporate. What you need to do now is you need to attend to the training of the employee, which is very, very important. I actually listened to an HR webinar this morning at Labour Smart, where they referred to disciplinary hearings, and one of it was very crucial point that is if you did not train your employee properly, it might be unfair dismissal. So always make sure that you train your employee properly. The probation period is honored for 3 months. If it's not been successful within 3 months, you are allowed to extend your probation period for another 3 months. all just to make sure that your training as the employer and the training for the employee is successful. At the end of the day, it's up to the employer to prove that they have done everything in their power to make it successful for the employee to join the company and to be successful within the company. So then we have the management of the performance and also the engagement and motivation. So the performance management is obviously where it comes down to after the training, the probation has been successful, the employee is there for a year or so, and then you need to make sure that the performance is still up on par to what the trustees or the body corporate wants from the employee. So the standards are set high, and it's up to you to make sure that you monitor your employees to perform at the best of their capacity so that we can have the best skills for the body corporate at the end of the day. Now, performance reviews takes place in different forms. So normally it takes place on salary incentives, bonus incentives, even a perfect thank you would be nice, to motivate your employees to still perform the utmost skills that they have and to, keep everyone happy as the employer with regards to the duties that they have to perform. So with performance review also comes is when an employee is at the point where you just want to pull your hair out of your head and say you have had enough. This is where disciplinary measures comes in. So disciplinary measures also takes different forms where you can have poor performance reviews, written warnings, obviously due to misconduct. So you have to decide the correct disciplinary measure to follow with regards to the conduct or the misconduct that has taken place from the employee side. We have the disciplinary hearings, retrenchments, voluntary separations, incapacity hearings when an employee is have a disease or is incapable to perform their duties to their utmost performance. So then we have incapacity hearings, and then we also have constructive dismissals. And the constructive dismissal is, for instance, where an employee resigns, but it is due to the fact that the employer made it impossible for the employee to continue with his services at the employer's side. So the disciplinary measures are different measures, and it has to be followed to the T according to LRA and to the processes it needs to be followed. Otherwise, it will end us up at the CCMA, which we would like to avoid at all times and at all costs. So the performance appraisals, like I said to you, that is the recognition. Performance appraisals normally comes with, you can do a questionnaire to the staff where you ask them about, what they have done for the company that contributed to the company's success, or what they would recommend for the company to do for them in return. Are there any improvements? So that is the type of questions that you will ask, or it can also come in with KPIs, which is then basically related to the role profile as such. So recognition comes in the form of a bonus, incentives, increases, or like I said, a perfect thank you would also be very nice. A thank you goes a long way. And then the very last part of an employee cycle, unfortunately, like I say, all good things come to an end, is the termination of employee. So the termination of employee also comes in different forms. It's either the employee resigns, or there was disciplinary measures that you had to take, like a disciplinary hearing, or a retrenchment, or a voluntary separation. So with the termination of employee, you normally have your termination letters. You have your UIF forms that are normally submitted to the Department of Labor, and you also assist the employee with a certificate of service, which he or she will use with the next intake if he should use it for interviews on the next employment, or want to submit it part of his curriculum. So that is in a nutshell this employee life cycle. Are there any questions?
No, we don't have any questions at this stage, Belinda.
We're moving on to the second slide. The slide that you see in front of you is a take-on list that we normally use when we take on a new building. This is from Trafalgar side. But it's also a good thing for the trustees or the caretakers to use when they take on a new employee. So for a payroll to be 100% successful, there are some crucial information that we do need in order for the payroll to run successfully. So when you look at the very first point, we are talking about the workman's compensation number, or the COIDA, like everyone knows it. So all buildings have to be registered for COIDA, and we all do know that it has to do with injury on duty, which is very important for everybody corporate to have this insurance, because it is when there's an injury on duty, the medical costs will be covered. See, also depending on if there's a letter of good standing in place. Then we also have a SARS pay-as-you-earn number. All buildings that are liable for SDL or have employees on payroll basically have to have their own pay-as-you-earn number registered at SARS. And this we use to do the submissions of the EMP 201s on a monthly basis. The EMP 201 is where we pay over the pay-as-you-earn taxes from the employee to SARS on a monthly basis. And then we do the RP5 submissions, which normally is due within March, between March and April within the next year, where we issue the RP5s to the staff members. Then we also have any information like, does the body corporate belong to a provident fund, which is also very important, because at the end of the day, we need to make sure that our employees are settled for when they want to retire one day. Then we also have the documents that we need is basically the 3 crucial documents for an employee, which first is your employment contract, which needs to be duly signed by all parties. And this includes every single page of the employment contract needs to be initialed by all parties. Also the last page, fully signed by all parties. Then your role profile, which I mentioned to you before, that basically tells the employee exactly what you expect from him. And then the bank confirmation or bank statement that we need in order to confirm the bank details. And number 1 is it has to be in the employee's own bank account, because SARS do not allow third parties' bank account details on payroll anymore. So in a nutshell, that is the documents that we need for a successful on-take onto payroll with any employee or any body corporate. So with the documents needed on payroll, like I said to you, there are 3 crucial documents that we all need. The employment contract, which is part of your basic conditions of your Employment Act. You can go and have a look at section 28 and 29. The Basic Conditions of Employment Act has also been made available to you, and we can also send the slides through to you if it will be easier. So the employment contract is basically an agreement between an employee and employer stating that the employee will deliver a service and the employer will pay for the skills. That's basically what, in a nutshell, what a contract is. So then we also need the employee ID document, which is also very important. And then the role profile, like we all say, the role profile, it is to provide the employee with the expectations that are required of the role. It must give enough detail to help the candidate to assess if they are suitable for the position, to support the recruitment team in a selection process. That is why we also use the role profile quite a lot. It also helps to formulate questions when you have an interview with the candidates. And then also allow prospective employee to determine their role or their standing within the structure of the organization. It's a legally binding contract of employment. It also set the goals and target of the employee once they join the company, and it also to aid in the evaluation of the employee's job performance. This is where the probation evaluation period comes from.
Right, I think Belinda might be having bandwidth issues there in Pretoria. Samira, do you want to just step in while Belinda's still connecting again?
Yes, for sure. Okay, so Belinda stopped at the role profile. Just before I continue with the role profile, I'd like to highlight why it's important to have a role profile and an employment contract. And it's important because it's effective and it helps in resolving disputes effectively. So it's very important that one should have employment contracts and role profiles on file.
Right, just I'll find the slides to put them up.
Yeah.
Belinda's reconnecting at the moment. So it's basically the caretakers are often involved in setting up the employment contract as well as the job spec or the role profile, so that this can then be included with the employment contract as part of these standard documents, which the HR department will require to run the payroll effectively. Is that a fair summary, Samira?
That's correct. And remember, we've got to have all the information on file so that when we submit to SARS or to UIF, all the information is 100% correct. We have a question, if I can take this, if Lenita can take this question for us. Is the body corporate allowed to hire foreigners?
Unmute there, please.
You need to unmute.
Apologies.
Go for it.
Apologies. Yes, provided that they have the correct documentation, being a passport or work permit, a valid work permit or asylum, and then also the banking details we would require, as well as the employment contract. So all the supporting documents must be in place.
It is one of our challenges where many buildings have employees from foreign African countries where all the documentation is not in place. And then that does place risk in terms of payroll, because there are issues in terms of SARS, in terms of submitting some of the reconciliations, and certainly making payment electronically into a correct bank account. Right, Belinda, if you can just bring up your slides, then you can carry on seamlessly from there, please.
Can you see the slides, Andrew?
Not just yet. It would appear that Belinda's bandwidth is unstable, Samira.
Andrew, I've got it. Would you like me to share it? I can share it.
Yeah, I can too. I've got it here. Right, so I think we can go on to the next slide, can we?
Yes, please, Andrew.
Okay. Right, Samira, carry on.
Okay, so there's two different types of employment contracts. So one is an independent contractor and one is an employment contract for an employee. So what is an independent contractor, you may ask? An independent contractor is someone that is employed on the basis of services provided. And so what does services provided means is that that person will provide a service and will provide an invoice upon the services concluded. So you see, it's not like an employee. It's totally different from an employee. And with the CCMA, the independent contractor cannot go to the CCMA because they don't have jurisdiction over independent contractors. Whereas an employee that's employed on an employment contract can go to the CCMA for dispute resolution. Okay. So the distinction between permanent and full-time and casual, sorry, Andrew, you went to the next slide.
Yeah, we've got Belinda now has taken over.
I'm sorry.
Okay, Belinda, yeah, so Samira was just finishing with the difference between a contractor and a full-time employee, and explaining that contractors are not able to escalate disputes to the CCMA, whilst full-time employees are. And the difference would be whether there's an employment contract in place signed with the individual, or a service contract as a consultant or an independent contractor. So I think we'll hand over back to you there, Belinda, to continue with the next slide. Thank you.
Thank you. Apologies about the disconnection. So I just want to confirm the previous slide if this is what you saw last before we can continue?
Yes.
Okay. So the standard role profile is exactly like we said. It is a job description and it's an essential part of the job application process. It contains the right information and it should help the applicant to determine whether the role is in line with their skill set and whether it is a job they actually want to do. And it helps to streamline the selection process as well. So like you can see, we have about 5 standard role profiles, which we can also send through to all the caretakers if that will assist them. But also keep in mind that any role profile can be amended so that it will suit the operational requirements of the body corporate and also the job at hand. Then the last document also for the take-on of a new employee is, of course, the employee's bank details. Like I said to you guys, we do not accept any third-party bank accounts, and that is SARS legislation because a lot of people would like to pay their salaries into someone else's bank account just so that they can avoid the tax payments. So all bank details, if you do submit a new employee, must be in the employee's own bank account. Foreigners can apply for bank accounts. There are no problems with that. Even the post office gives bank accounts. So there's really no reason why someone can't have their own bank account in South Africa. So you'll have 2 different types of bank details. Like you can see, the first one is if you have online banking, then you can retrieve the electronic internet banking statement from your online banking. And it looks like the one that you can see on the left-hand side. It has the stamp, like you can see there's a stamp on the right-hand corner, gives the date, and then at the bottom it will give the account confirmation letter with the details of the owner of that account. So it will give the employee's full names and surnames, include the ID number, and then at the bottom you will see it will give the banking details and also what type of account it is, because we also need to load that onto payroll. Then the second one that you can see is the type of bank confirmation letter that they will get from the bank branch itself. So it's basically more or less the same, similar details. In this case, it is just signed by someone individually who will give the bank confirmation letter, and it will have an actual stamp, like in the olden days, on the bank confirmation letter. If a bank confirmation does not have a bank stamp and it's not original, it is not acceptable. And this is normally where fraud comes in. Any questions?
Belinda, can we have 3 months bank statements instead of a bank confirmation letter?
No.
Okay.
The 3-month bank statements, if you have a bank statement, it still needs to have a bank stamp on it. So it doesn't have to be 3 months, but it will have to still have your bank statement on it. And I think, if I'm not mistaken, you can retrieve this from the ATM as well, where it gives you the bank stamp from the ATM as well. So 1 month bank statement is fine as long as we can see that bank stamp on the bank statement.
Thank you.
Belinda, could I ask you, well, one of the questions there is there a probation period once somebody has been appointed, a caretaker, for example, and how long does the probation continue until the employment becomes permanent?
Okay, there is normally a 3-month probation period, and that is normally also included within the contract, which is very important, so that the employee is aware of the probation period. Probation meetings will be held on a monthly basis to evaluate the performance of the employee. And if after 3 months the employee's performance is not quite 100% what the caretaker or the trustees would like it to be, they have the right to extend it for another 3 months just to make sure that the employee is a perfect fit. But in that period, they must make sure that training takes place. It's very, very important that the employer do everything in its power to make sure that the employee is equipped with all the skills that he needs. So then if after 3 months the trustees or the caretakers are happy, then obviously the contract will also state, you know what, it can then go over to permanent employment, or it can state that, you know, the probation period is successful and then a letter of succession will be given to the employee.
And I think also important to note that a probation period must be agreed upon before commencement of employment.
And that will be included within the contract, right, Samira?
That's correct, yes.
Yes. So then the basic conditions of the Employment Act. This is basically our Bible, if I could say it like that, in the HR term. We measure everything according to this. This changes regularly, so we have to be updated at all the time. This is also part of the IHA's posters that all the body corporates have to display for the employees, because the employees have the right to this information. What I have put on the slide is just, you know, a summary. It's a drop in the ocean of what is part of the Basic Conditions of Employment Act. The slide has also been made available, or a link for you to download the full Basic Conditions of Employment Act that you can familiarize yourself with. Or if it's a little bit too intense, you're more than welcome to email any of the Trafalgar HR managers and we will gladly assist you. So the most important, what is always a problem is, number one, is ordinary working hours. A lot of people don't know the ordinary working hours of a 5-day and a 6-day week. So that is what I have included, and that is part of Section 9 in the Basic Conditions of Employment Act. And the basic rule is it's a 9-hour per day, which includes 1 hour lunch. So that will basically say the employee have to work for 8 hours per day. So that is more or less how the working hours work, except for security staff or flexi hour staff. That all depends on, again, the job or role profile and the operational requirements of the body corporate. So this is not set in stone, as long as the working hours are more or less in line with the basic conditions of the Employment Act. Overtime also is very important. A lot of people don't know when it constitutes into overtime and what they have to pay. So we all do know on public holidays and on Sundays there are different rates that we pay. And then also the overtime is not always what we say set in stone to pay overtime. It depends also on the agreement with the body corporate, because a lot of employers can give time off in lieu for overtime work. So it all depends on, again, what the employer agrees with the employee within the employment contract.
Linda, could I ask you a good question that's just come up about temporary employees? So at what point does a temporary employee become permanent? And is there a probation period, or how are temporary employees managed in terms of the documentation or payroll process you've talked about?
Samira, this is your line of forte. I'm going to give it over to you.
Yes, I seem to have answered that question as well. So probation period is not required for a temp employee. A temp employee, as I read, it refers to a painter. The temp employee's contract will have a commencement date and a termination date. So not necessarily require a probation period for a temp employee. And on that note, for a temp employee, please remember the temp employees work less than 24 hours a month.
To say that again, Samira, they work less than 24 hours when?
A month.
Per month. Eh? If they work more than 24 hours per month, what does that mean?
They are deemed as a normal employee, a full-time employee.
Okay. And is there a 6-month parameter in terms of converting a temporary employee into a deemed permanent employee?
Once you reach the 24-hour period, you're deemed as a permanent employee. So that employee automatically falls under the basic conditions of employment.
And is that cumulative? So if you work for several weeks or months and you reach the 24-hour mark, does it become permanent at that point?
Yes.
Okay. Thank you. Carry on, Belinda.
So then we have the meal intervals, which I've explained to you is 1 hour. that forms part of the 9 hours. So in theory, the employee will only work 8 hours per day. Then the resting periods, that is more to do with also with especially security staff, which works shifts. And it's normally a 12-hour shift from 6 to 6 p.m. or vice versa. So it is very important to know that your especially the security needs to have their rest days, and there must be a rotation that they can't work week on and rotate the next week to another shift. So there has to be at least 2 to 3 days resting period for the security staff. Public holidays are self-explanatory. So public holidays, also again, security staff work on public holidays, again, agreement between employer and employee. And then on normal businesses or...
All right, we've just lost Belinda's sound, I think.
Lenita, you want to take over there? Okay, let me just go on a quick.
All right, just unmute there, please. Lenita, carry on.
Samira, if you don't mind, you can carry on.
Okay.
Thanks.
Belinda, you're on mute. Okay, so Belinda stopped. Okay, there we go. Belinda, you're back.
I'm back, sorry.
We didn't hear you for a while.
Okay, so back to the public holidays. It depends again on the agreement. Like I said, some security people will work on public holidays. Then that's what the employer must just take into consideration is that public holidays are paid at a double rate instead of just the normal 1 rate per day on the pay scale. And then obviously also again, public holidays, there might be another agreement. So again, the employer can decide, I can give you, a credit of leave if you work on a public holiday. So it doesn't always have to be a monetary. So you can always agree on something else in lieu of, again, the overtime worked on a public holiday. Now, annual leave, which is part of your section 20 and 21, this is very important, and I need to emphasize this to all employers or caretakers, is that they need to understand the difference between 21 consecutive days and 15 working days. In theory, if you put it in a nutshell, they're both exactly the same. But in the contract, it sometimes stipulates 21 consecutive days, and a lot of caretakers sees that as 21 working days, which is incorrect. So consecutive days means it includes weekends, Saturdays and Sundays as well. So I just needed to get the difference there so that everyone knows the word consecutive. If it's included in the contract, it means Saturday and Sundays are included. And in theory, the employee only gets 15 working days, which is 3 weeks holiday. So so you can elaborate that. And then on flexi-time workers, the employees that comes in once or twice a week, their leaves are normally calculated at 1 day for every 17 days worked. That's why it's very important that in the contract, it stipulates exactly what days does the employee work. Is it from Monday till Friday, Monday till Sunday, or is it every second Tuesday? So if it's a flexi-time worker, what normally happens on our side at Trafalgar Payroll, we do a manual calculation, which we do on a monthly basis to go and work out the exact number of days at the rate that the body corporate employed the employee, and that amount will then be paid over to the employee. So no one is overpaid or underpaid. It is exact to the amount what is due to them. Sick leave. That is also self-explanatory. You get your 6 weeks paid leave within a period of 36 months. Sick leave is also, remember that medical aid certificate or medical certificate from a registered doctor is important to submit, especially if an employee has been absent for more than 2 consecutive days, which means if the employee is absent on day 3, it is compulsory for the employee to submit a certified or a valid sick note in order to qualify for the sick leave. Also, it is very important to remember there's an 8-week period within the sick leave cycle of an employee. Should the employee be absent within that 8-week period, and it falls just before the 8-week period, the employee is also liable to bring a certificate to the employer, even if it's just for 1 day. Still needs to bring a sick note in order to qualify for the sick leave. And the reason for this is a lot of employees abuse sick leave, and this is a way to protect the employer not to have so many absenteeism, because absenteeism at the end of the day creates a liability. It's a financial liability to the employer. Then we have the maternity leave and paternal leave that has been approved. So maternity leave is 4 consecutive months unpaid. So that is according to the basic conditions of the Employment Act. With the unpaid leave, then the employee will then, the mommy, will then be issued with various forms from our side, HR side, to assist her with the maternity UIF claim. And then her salary will then also be stopped for the period that she is on maternity leave, for the period of 4 months. Also, the maternity period can be negotiated between the employer and employee. Should the employee want to maybe return, they can make an agreement and then decide, okay, the employee can come back on month 3, for instance, if she have a valid and reasonable backup system at home for the baby. It can be negotiated. Then we have 10 days per child unpaid leave, where they may claim UIF. This is the parental leave, 10 days per child. And then also adoption leave for any child under 2 years. And it falls under the same criteria. They may claim UIF for this. So this counts for female or male. It depends on if they can then apply for the parental leave as per Section 25A, which was approved. And then your family responsibility leave, only 3 days per annum is allowed for any employee. So none of these leave, maternity leave, sick leave, or family responsibility leave, can roll over to the next year. So if your cycle is not depleted by the end of your leave cycle, it does not mean it will roll over to the next year. So the family responsibility leave, if your cycle has been finished for this year, you will forfeit it. So for the family responsibility, you can use for the following reasons. When the employee's child is born or sick, in the event of a death of the employee's spouse or life partner, the employee's parents, adoptive parents, grandparents, when they are sick or if they have passed away, or with the adoption of a child adoption or a grandchild or sibling. And then also very important, if in doubt, the employer have the right to ask for any reasonable proof in order for the employee to qualify for the family responsibility leave. Any questions?
So Belinda, if somebody takes a chance with any of these leave provisions, will it automatically be allocated to paid leave? And if there's not sufficient paid leave, it would be treated as unpaid leave?
Okay. So what happens is, that's a very, very interesting question, Andrew. With any of the leave, except for maternity leave, with any of the leave, family responsibility and sick leave, if you do not have enough sick leave available or family responsibility leave available, it will then roll over to your annual leave. Should your annual leave be depleted in all 3 scenarios, then it will roll over to unpaid leave.
Thank you.
Okay, performance reviews, that is again where we said, you have to monitor your employee and to make sure that your employee is still performing at its best in order for the employer to get the best skills out of him. I mean, your money is worth it at the end of the day. So a performance review, what is a performance review? Performance review is a formal regulated feedback mechanism in which managers and other key stakeholders assess the employee's work performance. So it's not only, you know, when there's a misconduct and your employee is not performing, you can do it throughout the bank. You can do it with any of your employees. It's just to make sure that your employees know you are still monitoring them, and maybe you can give them feedback where you feel they've been lacking a bit, and then they can, you know, upskill their performance and be the employee that they used to be. So the document that you can see on the right-hand side is just an ordinary template that you can use for questions to ask and to see, you know, if in what criteria the employee falls and the skills where they need improvement on. So improvement is normally when it's like unsatisfactory and satisfactory. Those two, the very first two columns, that is normally when you have to try and help the employee to perform and, you know, better their skills at the end of the day, so the performance can be upskilled. Good and excellent is self-explanatory. That's where you have your top employees. So the document can be used for both disciplinary measurements. That's where you do your disciplinary hearings and all of that. And also on annual performance appraisals, where you do your increases or your bonus awards. So that is just a normal template, and that can also be sent through to you if you would like to use it. Then the last part of the employee cycle, which, like I said, all good things come to an end, is the termination of an employee. And this is exactly what I said to you, is we will supply, or the body corporate or employer must supply the employee with the following, which is a UI-19 form. And this is the form that is normally sent through to the Department of Labour, where they will activate the UIF, and then the employee can go and claim UIF should he be terminated. So what is a UI-19 form? It's a declaration of information of any employees and workers employed in a private household or commercial. And then what is the maximum UIF payout per month? That is, UIF benefits will be paid to all qualifying employees, ranging from a minimum amount of 3,500 to the maximum amount of 6,638 Rand. So UIF, like you all know, we've seen it on payslips. UIF gets deducted every month, and that is basically where we all get the TERS refunds now as well. They are digging into the UIF payments. So the calculation works out on a 2%, which is 1% for the employee contribution, and then also 1% from the employer contribution. So that the total 2% will then be paid over to SARS, or Department of Labour, and it will be allocated to the specific UIF number and to the employee's ID number, which is submitted then to them. So then also we can add the salary schedule form. That is normally a form that has to accompany every UI-19 form. So the salary schedule is basically where it gives the breakdown or the history of the employee's salary over a period of time. So I'm going to show you the difference between the two. This is how a UI-19 form looks like. I'm pretty sure everyone has seen one. So like you can see, it tells you exactly, if you look on top, it gives you the month of the termination. It also gives then the details of the UIF number that normally is get paid over, the pay-as-you-earn number, which the body corporates are all registered for with SARS, and then the name of the body corporate, and then also your employee's details at the bottom. Now, the employee's details shows exactly your employee ID number, name and surname, the salary that he received, the number of working hours that he has worked per month, and then the engagement date, and then the termination date. And then also very important is the reason of termination. So if you can see right at the bottom of the UI-19 form, you will see different reasons why it's a termination. So there has to be a code, and that code has to correspond with payroll in order for the Department of Labour to link up with payroll to see that it is actually valid and it corresponds with one another. Then also to indicate if the employee has contributed to UIF, yes or no. and that form will then be sent by the HR manager to Department of Labour. This form is no longer given to the employees. The reason because of fraud, and that's why we were instructed, rather let it come from the employer. You can always include the employee within your email sent to Department of Labour, but it's very important that this form comes from the employer itself. Then this is your salary schedule. Like you can see again, all the details of the employee, and then it will also give you the history of the employee salary for a couple of years. Normally we give about 5 years salary for in order to submit with the UR19 form to the Department of Labour. Then the last form that will form part of your termination pack is basically the certificate of service, and this can be given to the employee. It's always nice to give the employee the original, because then they can keep it for record keeping, and they can also then include copies of it with the curriculum if they want to, or submit it to the next employer if they want to apply for a vacancy that's available. Any questions thus far?
Belinda, maybe I can pose a question to Lunita. Can the performance review be used as a basis for starting a dismissal process for an employee?
Yes, you can use a performance review as a basis, because you're going to, especially if it's going into an incapacity hearing, if the employee is not suited for the position. So yes, Samira, you can.
Very good.
Belinda, there was a question. Somebody's very upset about their tea breaks and their smoke breaks that you didn't mention as part of the basic conditions of employment and the 9 hours with 1 hour lunch that is stipulated there. Can you clarify?
Of course. Andrew, the basic conditions of employment act gives a 1 hour lunch break. So now the lunch break and tea breaks and all of that again depends on the employer. Either they can give the employer a full 1 hour, or they can break up the 1 hour into half an hour lunch break and maybe 1 15-minute tea break or 2 10-minute tea breaks. So it all depends on the employer on what they want to do. Some employers even grant the employees a full lunch hour, and they can then be allowed 2 10-minute tea breaks, depending on the job. So for instance, if you have a gardener can have his 1 hour lunchtime in full capacity, but then he might have 2 10-minute tea breaks because he's working outside and it's hot. So it all depends on the employer as such. So you can do the 1 hour as a whole, as long as the lunch hours you can go over, but as long as you don't go under the 60 minutes for tea breaks or lunch hours.
Thank you. And Samira, Belinda, do foreign Africans with the necessary documentation, such as a ID book, etc., do they also pay UIF and have UIF numbers as well?
Yes. Yeah, all employees, foreigners included, even if they have the work permits, they do pay UIF, and they're also entitled to the same labor protection that South African citizens have.
Thank you.
We're moving on to the workmen's compensation. Like I mentioned to you earlier on, workmen's compensation is a very important insurance, if I can call it like that, to have, and that is mainly used for injury on duty. We all know that is the IODs. So the compensation fund is that the rule of thumb is that every employer that even if you have one employee, that you do register for the workmen's compensation fund. And it's also being done annually. So it's a once-off fee annually. So it's not like a monthly contribution that you have to pay. The assessments are done according to the number of employees that you have, and also the salary contributions that you make over a period of 12 months. So how do we pay the workmen's compensation? The HR or the caretakers or whoever is attending to the payroll will submit the return of earnings on annually, which normally opens up in April or March, April within the following year for the past year. So then the assessment will be done. We will get an invoice from the workman's compensation. It will give the assessment amount that needs to be paid, which is a once-off, and then that will be paid over to the workman's compensation. And after the payment has been allocated, we can then allocate a letter of good standing. The problem is if there's no letter of good standing, you can't claim from workman's compensation. So it is very advisable for all body corporates or employers to make sure that their workman's compensation is paid up to date every single year. So should an employee, for instance, get hurt at work, normally what will happen is the trustees or the caretakers will get the workman's compensation number from the PMs or even HR. The employee will be taken to the hospital. The hospital will be informed that this is an IOD, and they will then supply the hospital with the claim number, which is the 999 number for workman's compensation. The claim will be opened, and then obviously any correspondence are online going forward. So then the workman's compensation will then pay for any medical expenses for the employee. So there are several forms that needs to be completed, and that can also be sent through to all the caretakers. Normally it is the employer's report that basically gives the background of the accident that happened, the employee's affidavit to say what happened, and then obviously that will be sent through to the hospital when the employee is taken to the hospital in order for them to start the compensation claim number.
Linda?
Yes.
Can caretakers ask for evidence of payment for WCA? So proof of payment that the building is paying towards workman's compensation. Can a caretaker ask for that evidence?
Well, we normally would send that through to the stakeholders if proof of payment is required, but letter of good standings is what we can submit to the caretakers if needed.
Okay.
Right, and IOD stood for injured on duty, which is what you mentioned earlier there, Belinda. So if a building now didn't have good standing with the workman's compensation, what would happen in the event of an injury on duty?
Lenita?
Apologies, Belinda. You said, can you just ask the question again, Andrew?
Yeah, the question is, what would happen in the case of an employee injured on duty, but the employer and the building in this case was not in good standing with the workman's compensation?
We have had instances before where we would then go ahead and register the claim and then do the payment to the workers' compensation and thereafter request the letter of good standing. So if there's a payment outstanding, then we would attend to that payment urgently and then get the letter of good standing thereafter.
Okay. And Belinda, is it fair just to emphasize to everybody that it's not easy working with the workman's compensation commissioner? Their admin is very behind. They're very difficult to get responses from. It's very hard to get registration numbers, to get statements of account is almost like pulling teeth. So we've almost got somebody full-time trying to chase the workman's compensation statements and letters of good standing just to confirm that all of the admin and payments are correctly allocated, up to date, and that those letters of good standing can be provided for confirmation purposes. So just an emphasis that this is not one of the better performing government departments.
No, not at all, Andrew. You're quite right. So it is quite a challenge. And I mean, I think if someone sends through a query for workman's compensation, all our HR managers, you know, you get a tingle in your toe where you just want to ask the floor, you know, sink me in, because you know exactly what's going on at workman's compensation. It took us almost 3 years to get workman's compensation allocate funds that was paid into their accounts, and some of them are still not allocated. So it is quite a challenge, but we will pursue and we will win at the end of the day. So yeah, it is like any government institution, there's always a problem. Then the health and safety at work, which is also very, very important. And that is also part of your OSH posters that needs to be displayed at any body corporate for the employees to be able to see what their rights are. So in health and safety, it's short, is basically just to say to any employer and employee, it's both your duties to make sure that the work environment is a safe place to work in. So it's not just the employer's duty, it's also the employee. So we have the work environment must meet the minimum standards in terms of heat, light, first aid provision, etc. Employers have a responsibility for carrying out regular risks assessments, which normally happen on a 3-month basis by your health and safety team to make sure that everything is still on par, the standards are still correct, there's no risk for any employee to get hurt, because then we will have to make use of the Workmen's Compensation Fund. Then the employees have the responsibility to take all reasonable care in the use of the equipment, reporting hazards. Like I said, it's also the employee's responsibility. If you see something wrong within your working environment, report it to management or the caretaker or the trustees in order for them to take care of it in order to avoid any risks of injury. So there is an internet research link that you can also go and visit. It's a very good site to go and read up on and familiarize yourself what the duties are of the employer and the employee.
All right, Lunita, a good question for you is what is the situation if a contractor gets injured on site? So the exact question was a caretaker employed as a consultant, not a full-time employee, is injured on site. Does workmen's compensation apply? If not, what recourse does the contractor have to cover for injury on duty?
Andrew, the independent contractor would need to make sure that they are registered and with regards to the compensation that they've got the insurance. Samira, is that correct?
Yes, the independent contractor has to be self-insured for cover for injury on duty or while at the workplace. Yeah, it's very much the independent contractor's own cover.
And Samira, public liability insurance, which is typically part of a body corporate's insurance cover, would only cover the public in the event of injury, not necessarily an employee or the service providers working on site.
Yes, it depends what the contract or what the insurance policy states, but yes, it would only cover the people living on site, living at the building.
All right, thank you. Let's carry on, Belinda.
No problem. Okay, so again, here you can see that there's a link to a health and safety policy statement. That is also very important if there are 5 or more employees employed by a company. A health and safety policy statement is then required. It basically, if you do not mind, I just want to open it up for you, and then you can see. This is what a health and safety policy looks like. Can you see it? Where the place?
Yes.
Okay, so it's basically just the normal things like, you know, the company name, the brief description of what the company does, and then also that you are committed to conducting the business with the respect of care of people and environment. So this is just a normal template that any company can use or body corporate can use to have it in place. So you are basically just saying that you will do everything in your power to be risk-free and to make sure that your employees are then covered and have the high standard working environment that they need in order to perform their job.
Linda, what is the role of the managing agent in the recruitment process?
The role of the managing agent, that is if the body corporate would like the assistance of the managing agent, in this case Trafalgar, is to, you know, we can advertise for the vacant position. We can then collate all necessary CVs, which the skills then correspond with the role profile. and then we can shortlist the candidates. We can then also arrange the interviews for the trustees or caretakers for the candidates that are available. And then the caretakers and the trustees can then also let us know, listen, we're interested in 3 of the 5 that can you arrange a second interview? Then we will arrange a second interview for you. And then obviously we can also assist with the employment letter of appointment, the role profile, which we can assist with. And then also to make sure that the employee is then placed onto payroll. So with the admin and the recruitment part, Trafalgar can assist with any time. But at this stage, also, just keep in mind that the recruitment services and all of that will come at an additional cost to the body corporate, but the HR managers can assist if the body corporate requires it to.
Okay, thank you.
Then we have a provident fund. Now, I know that everyone knows that, a provident fund is not yet compulsory. However, we would like to, emphasize on it, that you can make a difference in your employees' retirement years. So Trafalgar has a fund, Sanlam Provident Fund, which we joined in order to assist the body corporates, especially for the lower scale or the blue collar workers, like we would call it. So the fund is a 4-in-1. It is a death cover, it is a disability cover, it has funeral benefits, and it's an actual provident fund for the retirement when the employee reaches the age of 65. So it's quite a lot. It's one comprehensive package that you get. That it's administrated by the Sanlam Corporate Fund. For all small businesses and even home employees. You can even put your domestic worker on this fund, which is quite nice. The members may also make additional payments. So it's not only the payment that is accordance to the salary, which in this case is a 10% contribution, which will now be split into 2, which is a 5% employee contribution, and then also a 5% employer contribution, which gives the 10% of the salary as a whole contribution to the fund. But if the employee would like to make an additional payment, they are more than welcome to, in order to make their provident fund stronger for the age of 65. So the communication, each employer, this is the body corporate, will be issued with a certificate of participation. Because remember, at the end of the day, it is the body corporate which is the actual fund member and not the employee. The employee falls under the body corporate. So the body corporate will be issued then with a certificate of participation. Each member or employee will be issued with a membership certificate once the first contribution has been received successfully. So this normally happens via payroll. Payroll, we do a deduction every month. If there's an increase, we will increase the provident fund, and we will make sure that Sanlam is always paid and 100% up to date. So the caretakers or the trustees do not have to worry about this. There's no debit orders or stop orders to sign. This is completely taken care of by the managing agent if the employee is on payroll. The member will also receive an annual benefit statement reflecting the following: the fund value, the cover for death, the cover for capital disability, and also funeral benefits. The benefit statement will be forwarded to the participating employer via the financial advisor for distribution among the members. So in this case, what will happen, Sanlam will send all the benefit statements through to the HR department at Trafalgar, and then Trafalgar HR will then distribute it to all the caretakers or trustees for them to hand it over to the employees. So the benefits for you as the employer, caretaker, trustees: retain your valuable employees. It is important that employee benefits minimize the risk of losing valuable employees. You can be assured of retaining your current employees and being able to offer an attractive, competitive package to all new employees. So, in a nutshell, it basically says if an employee sees on the letter of appointment, we give you a salary plus we offer a provident fund, the employee is more likely to accept your offer than where they only see a salary. So that is why it is very important, because you are investing in the retirement years of your employee. Then it's also peace of mind. Your responsibilities at the retirement and unforeseen death or disablement of your employees are reduced due to the provision in this tailor-made specialized fund. We all know unforeseen circumstances happen, and likely 99% of all our blue-collar workers are not even prepared for this. So if we can assist them and help them for the unforeseen circumstances, that shows exactly that we have value in our employees. And then ease of payment. Contributions are levied monthly in advance, and to make life easier for you, these are done by debit order, but in our case, it is done by Trafalgar Payroll, and then from Trafalgar's payroll salary account, a debit order has been submitted from Sanlam. The single contribution cover all funds benefits, including those offered through the separate group schemes. So we have an application form which the employer or the body corporate has to complete and send back. And then we have a beneficiary form. So the beneficiary form is exactly what it says. That gives us the feedback on what the employee wants us to do, or the fund to do with his money if something should happen to the employee. And that is very important to have that on file, not only the employee, but you can also send it through to the HR department for archiving, if it will be easier for the trustees or caretakers to retrieve it afterwards. Any questions?
This one for Lenita. Lenita, can an employer do random alcohol or substance testing on site?
Apologies, Andrew, you can continue.
This is a question about doing alcohol testing on site.
I see that Samira has also answered this question. She said yes, 100%, as they are legislated that the employees are not to work under heavy machinery if they're under the influence or substance abuse.
Okay, thanks. That's just of interest to everybody, I think. So I think the important questions, we're going to read them out loud as well as answer them online as well. All right, Belinda, we're going to need to move along. We have 15 minutes left, so if we can proceed quite quickly, please.
That's fine. The next few slides are just a cool toolkit for the caretakers. That is where I said to you the basic conditions of Employment Act. The full document can be viewed there. The attendance registers, the different samples that you can get and that you can use. Attendance registers are compulsory by the Department of Labour. So I would recommend for all caretakers and employers to have an attendance register on site. You can send it through to Trafalgar or your managing agent on a monthly basis for archiving purposes. Should the Department of Labour visit you, they will definitely ask for an attendance register. Leave application forms that you will need. There's a simple format that you can use. And then also how you can deal with absenteeism, discipline, the positive versus the punitive discipline measures, and then also a disciplinary code. Those are all the links to the full documents that you can read and familiarize yourself with them. Retrenchment, that is also a big word these days, especially with the COVID-19. Retrenchment works as follows. It is not a dismissal due to misconduct on the employee side. It's actually a no-fault dismissal. So this means that it normally happens due to operational requirements, or if the employer is financially unstable to continue with the employment relationship, and is basically forced to let the employer go not due to any misconduct from the employee side. So just to show you a calculation of retrenchment or a severance package that is normally paid, it's normally 1 notice month's wages, the current month wages, the annual leave as at the end of the termination date, and then also 1 week for every completed year of service. So this again is the difference between retrenchment versus retirement. Retrenchment is due to no fault misconduct of the employee, where retirement is where an employee comes to an age of retirement. So 60 years or even more, 65 years. And if there are no specified retirement age within the contract, you can always fall back on the retirement age of your provident fund. The CCMA info sheets, all the documents are there, easy for you to view. Disciplinary procedures, abscondent procedures, retrenchment procedures, and also the summary of the LRA. So if you follow those procedures, we will not visit the CCMA, that I can promise you. And then just last one, this is the any inquiries, this is the contact details of Lenita Adrian, the HR manager of Cape Town. And then also you can email myself. I'm the HR manager at Pretoria. And I would like to thank everyone for your participation in this training and all the valid questions that has been asked. There is a few more minutes if you would like to ask any more questions, and Samira, Lenita, and myself will gladly answer them for you.
Belinda, we have a question for Andrew. Is the caretaker allowed to send the tenants a warning letter for moving noise or making noise? I suppose it's making noise.
Yes, so what's important is the conduct rules. So the conduct rules provide the framework for dealing with any infringements in the complex. And typically they should sort of define the way in which the issues need to be addressed. So I would say, yes, it is permissible as long as the authority has been delegated to the caretaker and it's in line with the conduct rules. So we've actually done a whole webinar on enforcing the conduct rules. It is recorded and available, and if anyone's interested, I can circulate the YouTube link, and it goes through the whole description of how to enforce the conduct rules, what's important to make sure that the conduct rules are correctly registered with CSOS, and how to make sure that they are binding. And certainly the caretakers could play a role in it, but typically it would be the trustees or the portfolio managers that would ask them to send the warning letters on their behalf, and typically to deliver it to the tenants on site, because they would be able to achieve it more quickly and more easily. So hopefully that answers the question, but it's quite a long, complicated discussion. It's something that certainly keeps portfolio managers and the trustees very busy, and there's certainly important considerations to make sure that it's done effectively and correctly to try and achieve the right result. Can I ask a question back to Lenita? Lenita, is it possible to sell annual leave so you can actually get a monetary value from reducing your leave or from your accumulated leave?
No, Andrew, only on termination of employment. So you can't sell your leave instead of taking leave.
Maybe I can just add, it's one of our challenges as Trafalgar running payrolls is getting accurate leave applications and reports from the building. So many times employees will take leave, and that leave would be agreed correctly with the caretaker or the trustees, depending who's taking the leave. But then it's very important that those leave forms find their way back to the payroll managers so the leave can be recorded on the payroll system, and that the payroll system has an accurate record of when leave was taken and how many leave days are outstanding. And if that's not accurately maintained, leave balances accumulate. There's a financial risk to that, as you heard, and it becomes very difficult to manage, how much leave is available to take. So just a message to say, please do make sure that those leave forms are filled in correctly, that they're correctly authorized as per the defined procedures, and they must find their way to the payroll department by the portfolio manager or the trustees, however you generally do it. It can be by email, it can be by WhatsApp, but it's very important. And then Trafalgar does report to the trustees the monthly payroll, so that the trustees can see that everybody is paid and paid correctly, and the current leave balance of every employee is shown on that payroll report, just so that we can see that the leave is being tracked correctly. Samira, there are many questions coming in now, so over to you.
Okay. A lot of the questions are, okay, the question is for Andrew. I'm an independent contractor. I invoice in my own name to the body corporate every month. Do I rather register a company or invoice in my own name? Is there any benefit for rather registering a company?
All right, that would, I think, be best to speak to a financial advisor who would need to look at your tax position, and they would be able to advise you what is most tax efficient and most beneficial to you, and it really does involve your broader financial planning. But I would say it's very important that you do take that advice from a professional, and typically a personal financial planner would be the right person, and they would link onto that your retirement planning, insurance for risk and injury, as you asked about earlier, and just to make sure that you've got a holistic solution. So it wouldn't be easy to generalize or speculate here, because there's many issues and dependencies which would go into that decision, and there are trained professionals that specialize in exactly these type of questions. So Andre, I'm going to refer you to a personal financial planner. If you don't know of any, you can let us know. I can refer you to somebody. Otherwise, if you look online, that would also be a good idea. Okay, thank you.
Hey, Belinda, I have more leave days and I'm not going to take them. Can I sign for them and let my colleague who doesn't have to go on leave in my place?
That is totally illegal. No.
Okay, so maybe we should make it very clear that employees are to take leave. They must have a rest period within a 15 to 20 days.
Yes, yes, yes. And also keep in mind that the caretakers must keep in mind is your leave pay forms part of your remuneration package. So if you then hand it over to your employee, which also have, 20 days, you're doubling his remuneration package, which is also unfair to the employer.
Okay. When is a leave form submission expected? Immediately after the employee's leave, or when the employee requests the leave and is based on the leave days?
The second scenario, when the employee applies for leave, the rule of thumb is the employee cannot go on leave unless that form is approved by management or the caretaker or trustees, and both parties must sign the leave form to show that both parties agree to the leave period.
There's a question here about caretakers reporting maintenance issues. So I think it's a very important function of caretakers is to inspect the common property literally on a daily basis, and to play a key role in making sure that maintenance, and especially urgent maintenance, is attended to correctly. And that would be part of the job description and the procedures that are applicable on site in terms of how must maintenance be done, who is advised, who takes the decision, who calls out the service provider, and the caretakers would generally meet contractors on site, show them where the maintenance issues are located, and sign off the job cards once the maintenance work is completed to confirm that it has been done to their satisfaction. So caretakers play a really integral role in that, and good caretakers make sure that the common property of bodies, corporate and homeowners associations is very well presented all the time.
Okay.
Andrew, if I can just jump in here. I see that Kagiso also asked a question with regards to leaking pipes in a flat or a unit, and what must the caretaker do? And I just want to refer him back to the training we had last week with regards to the definition of a section. So my advice to him would be that if it's inside the unit, do not proceed in, appointing contractors, but immediately get into contact with the owner or the agent of that unit, because any work within a unit would be for the cost of the owner. So I just wanted to highlight that to him as well.
Thank you. Belinda, is the current leave balance shown on the monthly pay slips?
Yes, it is shown on the monthly pay slips, and also the 09 report forms part of the management pack that is sent out on a monthly basis. Yes.
So every employee does get a pay slip each and every month, and it gives the breakdown of the payroll and the monthly salary payment, as well as the leave balance. And if there are any queries or concerns about that, then they should raise that query typically with the payroll manager, the HR manager, yourselves. And if they don't have your direct contact details, they could do that through their portfolio manager or trustees. But it's very important that everybody does double check their payslip. That's why it's sent out. It's got important information. It should be checked and confirmed on a monthly basis. It's generated by the payroll system with the information loaded from the employment contract, as well as the leave forms which are submitted. And certainly the payroll managers in our HR departments are available to make sure that they are correct, accurate, and are meeting your understanding and expectations.
Andrew, I just need to also just let you know that we also do a leave report over 20 days on a monthly basis. So when there are any employees over 20 days, which then becomes a concern financially as a liability to the body corporate, we inform the PMs. The PMs then, in their turn, then informs the trustees in order either the employee to take leave so that we can decrease the leave days, or that we can do a recon on the leave history, because sometimes, you know, a leave form hasn't reached HR, and that's maybe where the problem is. But both scenarios normally gets fixed.
Thank you. Samira, can I ask you this one? What are the risks to a body corporate employer if they employ undocumented foreign nationals? And what rights do those undocumented foreign nationals have working at a complex?
It's unfortunate they don't have any rights according to the basic conditions of employment and South African law, labor law. You know, so if they don't have their permits or asylum certificates, unfortunately, they don't have any rights according to our labor law in South Africa. So, you know, I would strongly advise that the foreign nationals get all their documents in place so they can benefit from the labor laws in place and SARS and UIF and workmen's compensation.
So, I mean, once again, we have this challenge with many buildings employing undocumented foreign nationals. And because they find it difficult to open bank accounts, the buildings are often then required to pay them in cash.
Yes.
And not only is that a very big admin nightmare, it also creates significant risks in terms of trading in cash, delivering cash. The employees, they're not carrying their salaries in cash, which is a theft risk. So all round, it is a serious concern and should be avoided as far as practically possible. And I think Belinda emphasized that, you know, the documentation required is a valid work permit, a valid asylum seekers document, as well as an ID would all be required, or options for foreign nationals to work legally in this country. And in that case, we bypass all of those practical difficulties, and those people, those employees would then have full rights in terms of the basic conditions of Employment Act working at the complex. Is that correct?
Yes.
100% correct.
All right, have we answered all the questions, Samira?
One more for Adele. Can caretakers use common property for their own personal use, like the clubhouse?
No, unfortunately not. Common property is the undivided share of all the owners. So no, he can't.
And Adele, can a trustee be a caretaker, and what would happen with the remuneration element for the caretaker role?
So there's, they can do it with regards to a contract, the basic conditions of employment, or they can agree to a honorarium. And on a honorarium, they will have to get the permission from the owners with regards to on a special resolution, and then they can pay them on an honorarium or through a contract.
Okay, so it can be done, but it needs to be done correctly in terms of that special resolution. There are many trustees that do perform caretaker roles because they are obviously interested in the property. They would like to make sure it's well managed and well maintained. Typically, those people are resident on site and have time available to attend to that role. And typically, those people do it very well. But it is very important that the salary component is correctly confirmed with that special resolution and minuted so that there's no comeback or challenge in terms of payment. And that's
Yes.
because most trustees generally perform the trustee function of the role without any compensation. So they typically do that ex gratia in their personal time after hours. And that's, you know, that's the way the trustee role typically is configured. Right, well, we've just reached 4:30. Samira, are there any other topics you want to cover in closing?
Hillian raised an important topic here, that the leave reports may differ on a monthly basis due to timing. So when we close off for payroll, those are the leave forms that we get, we will capture, but we may even receive leave forms after payroll is closed. So those leave forms are captured in the next month. That's just for the caretakers to be aware.
And your payroll closes on the 21st of each month, is it?
It closes on the 17th, between the 16th and 17th of the month. It depends on which day it falls on.
Okay, and then those delayed leave forms would be captured in the next payroll
The
cycle.
month after. That's correct, yes.
Yeah. All right, everybody. Thank you very much indeed for attending. Thank you to the panelists. I hope everybody found it interesting. We've got many requests for the presentation to be sent out. It is a large presentation, and with all the links, it works out to 9 megabytes. For those that might have difficulties with email sizes, we can also send a PDF version, but the links wouldn't work in the PDF version. So we will try the larger version. If that fails, we can send the PDF version. So hopefully that did give you a good outline of important HR practices, legal considerations, and the importance of following all of those correctly. And then a reminder that we'll convene next week on Tuesday at 3 o'clock. The topic will be maintenance, as well as the considerations for occupational health and safety at complexes, which is a very important topic, as you'd expect. We did touch on it today, and we hope to see you there again next week. So good afternoon, everybody. Thank you, and we look forward to seeing you next Tuesday. Bye now.
Thank you.
Bye. Bye.